federal election law is kind of interesting. You actually have a legal right to ask the Federal Election Commission a question, and they have a legal duty to provide you an answer, and in a fairly short period of time, 60 days. And so one of the very first things I did in 2010 was ask on behalf of a committee called the National Defense PAC, can they be both a traditional political action committee and this brand new, newfangled super PAC that had just come out a few months earlier? And so the FEC deadlocked. There's 6 commissioners, 3 Republicans, 3 Democrats, and from time to time they don't agree, and when they deadlock, no decisions rendered. But you also have a statutory right to sue the FEC. If they don't issue an advisory opinion, or if they deadlock, or if you just disagree with them, you can go straight to court. And so that's what we did on behalf of Admiral James J. Kerry and the National Defense PAC. The case became Kerry v. FEC, and we ultimately won on a fairly early on to the process in a preliminary injunction. And what Kerry did was create a whole new kind of political action committee called the hybrid PAC. So right up until Citizens United, you always had traditional PACs. They could raise $5,000 from any U.S. individual person, and they could use that money for any political purpose they want, including giving to candidates. And then you also had super PACs, which started after Citizens United and a companion case called Speech Now that March of 2010. And that said, you can raise unlimited money from any individual or any corporate entity, and you can use that money for any purpose except giving directly to candidates. And Kerry was about, why can't I just have one entity that does both of these things? It's a hybrid of the two. And so we won the case and started hybrid PACs. I think there's about 180 hybrid PACs now, and increasingly they are a bigger and bigger part of the political puzzle, because sophisticated operators understand you use small hard dollars that you can give to candidates in order to advance your ideas and your opinions here in DC, and use big money to run ad campaigns out in the districts to get those guys elected. And so it's a great combination of powers that's available to these groups. In fact, a couple of our clients, which were the numbers 1 and 4 largest PACs in the 2016 election, were both hybrid PACs. So Sean McCutcheon was an engineer from Alabama, small business owner, did a lot of work on heavy industrial machines, and he'd gotten very interested in politics. And so he and I had worked on a few political action committee projects. So one time, Sean was reaching out to the Alabama Republican Party, the state party, and he was donating to them. And they told him, Sean, you're gonna hit your aggregate limit. You're not allowed to give us any more money. And Sean had no idea what they were talking about. And I'm like, Sean, there's a bunch of guys in Washington, D.C. who are telling you how many candidates and how many organizations you can support with your own money. How do you feel about that? And Sean didn't like it. And so Sean let us sue on his behalf to strike aggregate limits. First, we filed an advisory opinion request with the FEC, which ruled against us, as we really knew was going to happen. And then we took that and we went to the U.S. District Court for the District of Columbia, and we went to a 3-judge panel because this is a special part of the law, the old McCain-Feingold law. And while we were doing that, the Republican National Committee, the RNC, they got involved in the case because they cared a lot about this. They had donors who couldn't max out to them. And so working with the RNC, we went to the district court. They ruled against us. We sought immediate, and again, we knew this was going to happen at the 3-judge panel. And then we sought certiorari to the Supreme Court, which took our case. And we were able to argue for not this standard of law that Sean didn't care about in the first place, which is really technical and really dull. We got to talk about Sean as a guy who wanted to donate to candidates. Sean wanted to give every candidate $1,776, $1,776. Very cool thing. And he got stopped at about 20 some odd candidates, and he just wanted to keep going. And so ultimately, the Supreme Court agreed with us that, you know, if I can give you as a candidate 1776 and it's not corrupting to you, it doesn't matter how many candidates I give that money to, it's not going to corrupt any one of them. The old system was, well, I mean, once you give it to that 19th candidate, boom, everyone's corrupted. And that's silly. And so the Supreme Court ruled for Sean in 2014. It was a great win, called McCutcheon v. FEC.